was not accounted for. And so today, the High Court is actually sitting on that matter, the no-case submission, which was made by the Dr. Samura Kamara lawyers. But our man, Amanullah Manaba, is in the court now. Let's see if we can join him with regards to what is happening currently at the court. Hello, Amanullah Manaba.
David Remy Wilson, good morning. Good morning to you, to our listeners and viewers right across the country and the world. We are broadcasting live from inside the main law courts building at court number 1, where the Honorable Justice Adrian Fisher will be giving a judgment today on a no-case submission that was filed by, as you clearly mentioned, Dr. Samura, lawyers defending Dr. Samura, Matthew Wilson Kamara, who in November 2021 was indicted amongst 4 other people on allegations of corruption, which has to do with renovation or rehabilitation of the Chancery building, the Selion Chancery building in New York. According to the allegations, some monies were misappropriated. Putting this into context, you know, there were some donations from the Chinese government to the government of Selion for the rehabilitation of the Chancery building in New York. The Anti-Corruption Commission, this has been a matter that was captured in the audit report some years ago, and the ACC opened a case into it. They investigated and ended up indicting Dr. Samura Kamara and other 4 others, people who worked for government at the Selion mission in New York, then people who worked at the foreign ministry as well were indicted. They've been coming to court all this while. At some point, there was even a delegation from Selion that traveled to New York to ascertain some of the allegations. I understand that was with the judge as well. So we are in the court. It's half packed full. As you can see, the camera operator can put the screen on the lawyers down there. You have a battery of lawyers who are here to represent Dr. Samura Kamara. And the lawyers are representing Dr. Samura Kamara. You have the former Attorney General and Minister of Justice Franklin Baikabia. You have also another former Attorney General and Minister of Justice, Joseph Fiji Kamara. You have Melron Liquid Wilson. He's a very renowned lawyer in Selion. You have lawyer Alpha Jallo. They are all your lawyer. Sulaiman Kabakuma, lawyer Adi Makoli, who also served as commissioner of the Anti-Corruption Commission. So I'm seeing more lawyers here to represent Dr. Samura Kamara than the number of lawyers who are here representing the Anti-Corruption Commission. Dr. Samura Kamara is himself in here. He's here. His wife is here. His running mate in the 2018 elections, Honorable Cherno Ramadan Majuba, is also here, and other members of the APC, other supporters and members of the APC are here with him. But what we should also notice that Dr. Samura Kamara is coming into this case today not as any other ordinary citizen. Just few days ago, he was elected in McKinney as the flag bearer, the leader of the main opposition, All People's Congress, and their presidential candidate for the June 24th national election. So today he's appearing in court not as the aspirant then who wanted to lead the main opposition party. He's coming into this case today where his lawyers are seeking no case of as the presidential candidate of the main opposition, the APC. So the judgment perhaps today will have significance on his political ambition and as he moves around to campaign. Again, we must let our viewers understand that this is unprecedented. It has been hardly having the media coming to the courts to cover cases. Media to come and broadcast live proceedings and happenings. We're still waiting for the arrival of the judge, his Honorable Justice Adrian Fisher, who we understand will be appearing very soon, will be coming into the court very soon. As we see from right up there, a lot of people coming in, trying to settle down to ensure that the High Court Judge, Honorable Justice Adrian Fisher, take his seat and possibly deliver his judgment today. And it's not a packed full court, but there are people around, presumably or supposedly supporters of the presidential candidate. Meeting with him, they were discussing with him and laughing as well. But we've been joined by Elkas Sano. He's the Director of Communications at the Judiciary of Sierra Leone. Elkas, once more, welcome to AYV. You were at AYV this morning, but welcome from the Law Court building.
Thank you. I'm happy to be here again.
Elkas, this matter has been ongoing, but this is the first time today you're allowing the media to come and do a live broadcast, a live proceeding of the matter. What's the rationale for that?
The reason for allowing live media coverage is because we wanted transparency, we wanted integrity in the judicial process. Mark you, this matter involves the standard bearer of the main opposition, All People's Congress, Dr. Samura Wilson Kamara, and others. The matter is called the state versus Saidu Nalu and others. But the reason why we think we should continue to constantly allow media to cover its life is, in fact, we want to dispel rumor mongerings. We want to be on top of situation in terms of providing the much needed information, because what we realize as a media practitioner, as somebody who believes in accountability and transparency, we just have this conviction that when you allow information gap, at the end of the day, people will fill it with the wrong information. And to dispel rumors or fake news is very much expensive. So we want to be on top of situation. We want to see a situation wherein people who continue to repose confidence in the judiciary under the leadership of the current Chief Justice, Lord Chief Justice Desmond Babatunde Edwards, to continue to have confidence in the entire process, to continue to have confidence in the judiciary, because the judiciary is a creature of the Sierra Leone Constitution, and we are duty bound to hear cases from aggrieved persons who approaches the court. So this is not a novelty. Like AYB was here for the Supreme Court case, and AYB is here again to cover the no case submission. That's shortly. Judge was actually not here. Let me apologize. Chief Justice, management and staff of the Judiciary of the Republic of Sierra Leone, that the judge who is presiding over this case was not around. He has just arrived shortly. is preparing to come. Shortly, the judge will come.
We are getting the announcement, which clearly means there is going to be his ruling, is delivering his judgment. But I want to ask, is this happening because of the profile of the individual? Dr. Samura Kamara, like you mentioned, is the standard bearer, he's the leader of the main opposition. Is the judiciary doing this because of his profile, his position in society?
We cannot preclude that, but we've set that standard, and we don't want that credibility, that trust to diminish. So we want to uphold that standard, want to maintain the status quo as it is, to making sure you don't necessarily need to come to court. You just need to have your Android phone, sit wherever you are, either in your bed, parlor, or whatsoever, and follow what obtains in court. We want to maintain that standard. We want to enhance, because what we've noticed is that transparency builds trust. Accountability will inspire confidence in the entire process. So that's why we want to maintain.
Is the judiciary under pressure? Very recently, we saw issues about, the international community meeting with the Chief Justice about a certain matter that involves the main opposition, APC, and now we are seeing the flag bearer coming to court today, a matter that started in 2021, and you are opening up the judiciary to the media to broadcast. Are you under pressure?
No. The judiciary, we cannot in any way surrender our independence to the whims and caprices of international pressure. We are an independent arm of government. By provision of Section 120, subsection 3, it states that we are only answerable to laws legislated by Parliament and the Sierra Leone Constitution. In fact, the woman I want to dismiss, thankfully, most of those meetings with the international community, international partners, I have been in attendance. For instance, when we went to the U.S. Embassy, I was in attendance. When the UN resident representative came here, I was here. I was in attendance. The EU, I was also in attendance. What the reason for their visit, or the reason for those meetings, they came to ask our preparedness, to tell them how readily prepared the judiciary is, where there is funding gap, where we think there are challenges, where necessary they can come on board. And we did not hide it. The Chief Justice has been so bold to tell them that yes, we want justice everywhere in the world. Is expensive, but we have limited financial support. We need money. We need money now. One of the things we want to do is to deploy judges across the country, and because we have what we call the electoral court. We now have an electoral court for these elections. So this electoral court, it requires us to deploy judges everywhere, and most of our judges are without vehicle, and we need magistrates. Most of our 34 of our magistrates are without vehicle.
Okay, Elkas will end it there. The judge is already here. His Honorable Justice Edian Fisher has taken his seat, as you can see down there. He is already seated, and he will be delivering his judgment pretty soon. So we are broadcasting live from the main law courts building here on Shaka Stephen Street, Bademba Road. So we'll now join the other camera to connect with the judge, who pretty soon, I believe, will be delivering his judgment. Thank you for watching, and continue to watch AY.
Adikali for the Suma, for the Vafumba Bawo, Samura Matthew Wilson Kamara, Kande Fode Basil Kamara, and Julius Sanders Davis.
Yes, good morning. Representations, please.
For the prosecution, CT Mansebo, and with me, v. Robin Manson, Kenneth Conte, and E.K. Kamara.
Yes, thank you very much. First accused. Thank you very much. Second accused.
Second accused, Ibrahim Sori. Ibrahim Sori, Africano Sori Sise, Brahima Kuroma, and Jerilyn Manley, Spain.
Thank you very much. Third accused. Fourth.
Good morning, my lord. For the fourth accused, Franklin Baikabo, Ambassador Amadou A. Koroma, Melron C. Nicole Wilson, Musa Nu Kamara, Suleiman Kaba Koroma, Africanos Sise, our own Adi Macaulay, Brahima Koroma, Radcliffe Jones, Roland Nylander, Jerilyn Manley, Spain, E.B. Touré, A. Boise Kamara.
Right, where's Mr. Touré? I can't say. No, it's not seen. Yes.
I.A. Kamara, A. Boise Kamara, M. Berete, Festus Robin Taylor, Adama Amara, and S. Ba.
Mr. Nicole Wilson, is there going to be space on the ruling to incorporate all of those names?
We hope so, my lord.
Yes, I know Mr. Kamara will say there are more coming. All right, where's Teddy Koma? Yes. Yes, indeed. Okay, sit down, gentlemen. Yes, thank you. Right, I have to say, Council, is going to be a lengthy ruling. It goes into some 100 pages. So it will take some time to deliberate. Okay? All right. This ruling concerns the no-case submissions raised by the accused persons at the close of the prosecution's case in this trial. When the matter came up for hearing, City Man Sibo for the state informed the court that the prosecution wished to close its case, but was concerned that there might be a need to reopen the case subsequent to the locus in co visit which the court was proposing to make to the scene in New York. He therefore considered it prudent to defer the closing of the prosecution's case pending the locus visit. Counsel for the defense were of the view that it was appropriate for the prosecution to close its case to enable them to determine how to put their defense. All counsel were of the view that necessary. With these assurances, Mr. Mansibo decided to close the prosecution's case after an amendment to the indictment was granted. The accused persons, save for the sixth accused, subsequently pleaded not guilty to the amended indictment, and at this stage, the prosecution closed its case. When the matter accused persons informed the court that they intended to make no case submissions on behalf of the accused persons, which would be in writing. Directions were issued for the no case submission on behalf of the accused to be submitted to the court in writing by the 31st of December 2022, and for counsel for the state to file a response by the 15th day of January 2023. There was non-compliance on all sides with these directions owing to the late submissions, in particular with respect to the fifth accused, which meant that the prosecution could only file a response on the 8th of February 2023. Notwithstanding, I subsequently received the no case submissions file on behalf of the accused and the replies thereto by the prosecution. On a point of principle and law, it must be pointed out at this stage that this ruling is not intended to, nor is it indicative of the guilt or innocence of any of the accused persons. It is merely determinative of the submissions made by the prosecution are sufficient to amount to a prima facie case against the accused persons, thus requiring them to be put that at the end of the case, the prosecution is unable to discharge the burden of proof. For the purposes of these submissions have been assessed to the lower standard of proof, which is the sufficiency of evidence test. Contrary to the submissions of defense counsel, the beyond the reasonable doubt test is only utilized in the determination of guilt or innocence, and to that extent, I have not utilized that test. These submissions are a culmination of a very long trial in which the prosecution led 18 witnesses, which were extensively cross-examined by counsel for the accused persons, in particular the first and the fourth accused persons, as is their right to do so. I deal with no case submissions. In criminal cases, whenever an accused raises the issue of a no case submission at the end of the prosecution's case, it is the duty of the trial judge to determine whether to uphold the no case submission or, in the alternative, whether to dismiss it. The applicable test is that set out by the courts in the case of R.V. Galbraith, 1981, One Weekly Law Report 1039 at 1042C. And the test as set out in Galbraith can be encapsulated as follows. 1. If there is no evidence that the crime alleged has been committed by the defendant, there is no difficulty. The judge will stop the case. The difficulty arises where there is some evidence, but it is of a tenuous character, for example, because of with other evidence. Evidence taken at its highest is such that a jury properly directed could not properly convict on it, it is his duty on a no-case submission being made to stop the case. Where, however, the prosecution evidence is such that its strength or weakness depends on the view to be taken of a witness's reliability or other matters which are generally speaking within the province of the jury, and where on one possible view of the facts there is evidence on which the jury can properly come to the conclusion that the defendant is guilty, then the judge should allow the matter to be tried by the jury, as per Lord Lane, Chief Justice, at page 127. In simple terms, the Galbraith test means that there are two separate limbs for the defense to consider when making a submission of no answer. Limb 1, there is no evidence upon which the jury could convict. Or limb 2, there is some evidence, but it is so poor that it would be unsafe to leave it to the jury. Conclusion that the defendant is guilty, then the judge should allow the matter to be tried by the jury, or as in this case, the tribunal of fact. Having set out the applicable test and the approach to consideration of a no-case submission, I shall now proceed to consider the submissions advanced on behalf of the accused persons, starting with the first accused and the responses thereto. The first accused is charged with 30 count offences contrary to the Anti-Corruption Act 2019 in count 16. Failure to comply with the applicable procedures and guidelines relating to the management of funds, contrary to section 48(2)(b) of the Anti-Corruption Act number 12 as amended by the 2019 Act as contained in count 17, 19, 21, 23, 26, 28, 30, 32, and 41. For conspiracy to commit a corruption offence, contrary to section 128 of the Anti-Corruption Act number 12 of 2008 as amended, as contained in counts 25, 42, and 46 accordingly. 5. Abuse of office contrary contrary to section 43 of the Anti-Corruption Act number 12 as amended and as contained in count 44. The prosecution called 18 witnesses against the accused persons, and I shall carefully consider the submissions made by Mr. MP Fofana of Council on behalf of the accused on a count-by-count basis. Count 16. With respect to count 16, Mr. Fofana submitted as follows: that the first accused did not tender or award any contract at all to Fairfield Construction Associates Limited, inclusive of awarding a contract for additional works to them. The first accused met, dealt with, and operated within an existing valid contract dated the 9th of December 2016, which was lawfully executed between the government of Sierra Leone, represented by the then Sierra Leone Permanent Mission to the United Nations in New York as owner, and Fairfield Construction Associates LLC, represented by Mr. Jules Sanders Davis as president and managing member as contractor, and he therefore relied upon Exhibit U. The said contract specifies at Article 16, paragraph 16 on pages 17 to 18 how changes can be made to the basic character, design, or scope of the project, and so forth, leading to what it described as change orders. 2, that the first accused never tendered or awarded any contract for additional works to Fairfield Construction Associates, nor did the latter complain about the first accused attempting to do so under the existing contract. Besides, the existing contract makes provision for events of default, quote unquote, in the agreement, and for its termination or suspension by either party, as set out in Article 10, paragraph 10, at pages 11 to 14. He further argued that neither the prosecution nor the state of Sierra Leone invoked the above clause in pursuit of the purported non-performance or default in the performance of the contract. The change orders were done in 2019 or on about mid-2019, and not the 2018 period referred to in count 16, and that Fairfield Construction Limited acknowledged receipt of monies paid out to them on the change orders 1 and 2 in the sum of 542,000 United States dollars and 243,555,000 United States dollars, respectively, from the first accused as head of Chancery by letter dated the 1st of July 2019. These documents referred to were in Exhibit AAY 1 to 4, which was a progress report written by one Alan George. He relied upon Article 13, paragraph 2310 at page 23, which stipulates that the agreement in question shall be governed by the laws of the state of New York, both as to interpretation and performance, and shall be subject to the jurisdiction of the Supreme Court of the state of New York. He argued that it was therefore unclear to the first accused as to why he is accused of committing an offense in the city of New York, United States of America, under the existing contract, and is being tried extraterritorially in the jurisdiction of Sierra Leone. He further argued that the prosecution has throughout its case consistently failed to state and produce to the court the applicable procedure